Hello and welcome everybody to today's webinar, Brexit, Data Protection and Heritage, What You Need to Know. My name is Carmen Talbot and I'm the Project Manager for Heritage Digital. I'm delighted to welcome you to the webinar as part of our National Lottery Heritage Funded Heritage Digital programme. A bit of introduction and background coming up from me before we start. Heritage Digital is a consortium of 4 partners fusing heritage and digital skill experience. Together, we create free, high-quality digital skills training, events and resources for the UK heritage sector, and we welcome staff, volunteers, trustees and freelancers associated with heritage organisations to engage with our programme. The project is led by the Heritage Alliance, and we are a charity promoting the central role of the independent heritage sector. We're a membership body of over 150 organisations, and if you are interested in joining or supporting our work, do get in touch. And the main work of the Alliance is to influence the government on behalf of the independent heritage movement and facilitate connections between organisations within and outside of the sector. We also run capacity building and support projects like this one, and also our other National Lottery Heritage Fund supported COVID-19 response programme, Rebuilding Heritage. Now, our project partners, Charity Digital are our digital technology specialist partner and host of the project website and mailing list and event managers of all of our webinars and virtual events. It is their expertise that makes everything run so smoothly. The Media Trust are our digital comms and marketing specialist partners. They're designers of our beautiful downloadable guides and are linked to leading organisations in the world of digital through their corporate partners. Finally, today's webinar hosts are our digital rights specialists, Naomi Corn Associates. It is very, very likely that some of you in the virtual room today have heard of them already. They are one of the UK's leading information management specialist consultancies, and they specialise in intellectual property rights, data protection and licensing, and they lead on support for these topics across heritage and arts. Naomi Corn Associates support their clients to develop better rights and privacy policies and awareness through training and consultancy services. Particularly relevant to this webinar, they are also about to release a toolkit for archivists on data protection commissioned by the National Archives. Now, before I ask Naomi to join me, there are a few housekeeping points. The presentation element today will be 45 minutes long and includes some of the pre-submitted questions that happened on the Padlet we circulated. There'll be 15 minutes at the end for questions, and if you have a question for Naomi, please type it in the box marked Q&A at the bottom of your screen. In all of our webinars on the Heritage Digital programme to date, we have received far more questions than we've had time to answer. So if we can't get to yours, we will look to cover it in the accompanying digital guide. Feel free to use the general chat box. I can see people are already introducing themselves. Please introduce yourself and flag any technical issues you might have, and we will help you. Now, the recording of this session and the presentation slides will be made publicly available after the event and emailed directly to everyone on the Heritage Digital mailing list. And we aim to get this done in the next few weeks. We are using an AI captioning service for this event, so we're on Zoom today. If you look at the bottom of your screen, you should see an icon that says CC or closed captions. You can toggle that on and off as you need to. And you heard me mention above a forthcoming guide. There will be a downloadable guide to support this webinar coming out in March, and there will be a further webinar also this time next week on the impact of Brexit to intellectual property rights. Finally, we hope you enjoy this webinar and will give us feedback via the form sent out after the event. Now, I am delighted to introduce your speaker for the session today, Naomi Corn. Please join me on the screen. As if by magic. So a brief introduction of Naomi. She's the founder and managing director of Naomi Corn Associates. Naomi is one of the UK's leading experts in copyright, data protection and GDPR, as well as rights and licensing. Now, she's been supporting the public, corporate, education and charity sectors on rights management and rights exploitation for the last 20 years. Welcome, Naomi.
Thank you, Carmen, and thank you so much, everyone, for joining us. I've been looking at the figures, and I think it's fair to say that this is probably the most popular webinar now that we've ever run through the Heritage Digital strand. So I'm super excited, and I'm really, really excited to welcome you to this webinar. Today's topic is going to be, as Carmen said, all about Brexit, data protection and heritage. Now, I've been doing a lot of research, both pre-Brexit and also post-Brexit, looking at some of the impact. I am not covering everything that there is to do with data protection and Brexit, but what I will be doing is focusing in on what you need to know about as heritage organisations. Now, I had a little look at the list of who we've got joining us today, and I can see that there's a massive variation in terms of the organisations. We've got small, independent, local authority, medium-sized charities, large national heritage organisations. So again, a very warm welcome to you all. And I hope that the topics that I've focused in on today will be those that will be relevant for you and what you do. But more than that, what I've really tried hard to do is to give you some practical steps, things you need to be doing following today's webinar. Okay, now I've also embedded within the webinar today the questions that some of you have sent through on Padlet. So huge thanks from us for those of you who have gone on Padlet and also have indicated the ones that are most relevant to you. And what we'll be doing, as Carmen said, is giving you some time at the end of the webinar to just unpick more issues as they occur to you.
I'm going to leave you now, Naomi, and then I will monitor the Q&A and pop back up as if by magic at the end.
That's lovely. Thanks, Carmen. See you in a bit. See you at the other end. All right. Thank you very much indeed. Okie dokie. So just a few words. Now, I'm nothing without the team that supports me at the ranch. So that's Patrick and Maddie. Some of you may know them. I want to give them a big shout out because they have been just unbelievable during lockdown in the last year. They've gone over and above, and it's meant that as a company, we've been able to support you better both with the business related stuff we've been doing for some of you, but also all the free resources and help resources we've provided. So again, huge shout out to my team that have just been amazing during this last year. Now, the issues that we're going to be covering, as I said, I've focused in on some of the key areas as they have arisen. And so what we're going to be looking at is, first of all, what does Brexit mean regarding GDPR? We're going to be looking at the role of the Information Commissioner's Office, who are the main regulatory body for the UK. What does that mean? We're going to be looking at something called adequacy and what you need to be doing next. There have been murmurings, I know, behind the scenes about EU representation. How does that work with regards to data protection and what you should be thinking about? A word about the EU domains issue as well. And then finally, although this isn't exactly about Brexit, but I wanted to pop it in, we've got the Shreems case and the relevance for us in the UK and what we need to be thinking about. So within all of that, we're going to then be considering how do you need to change what you're doing now? What are your key compliance obligations? And as I said, we're going to give you some time for questions as well. But before we get going, we've got a little poll for you. We would like to know right now, what do you think, or how do you think Brexit will affect your organisation's activities that involve personal data? So before we start our journey, we're going to make the poll live for you. As soon as we do, if you could add your answers, and then we will run through the responses. So I'm going to give you about 20 seconds or so to get your answers in. So if we could have the poll open, and we'll give you about 20 seconds, and then we'll review the answers for you. So over to you. Okay, so you should all have the poll up in front of you. Another few seconds just to put in your responses. Okay, everyone likes a good vote. Right, so if we could have the answers up, please. Thank you very much indeed. I am now going to tell you that at this point, 47% of you, so that's 128 of you, think that Brexit will affect your activities. We've got 4%, so that's 12 of you, think it won't. Okay, so a very small percentage think that it won't. 27% think maybe, so that's 73 of you. And we've got 60 of you, that's 22% of you think or don't know right now. Okay, so we'll map the changes and see what you think after the webinar today. So thank you all very much indeed for voting. That's super. And just to let you know that we now have 305 of you online, which is absolutely brilliant. So lovely to see you all join us today. So let's move on with the presentation. It'll take about another 35 minutes, and then we'll get some questions from you. So let's set the scene. Okay, now in the UK, the data protection legislation is comprised of both the Data Protection Act and also, and this is a bit of a clue, the UK General Data Protection Regulation, UK GDPR. Okay, and all of this relates to the processing of personal data. And I'll unpick that in a little bit in a moment, but what I do want to say before we go any further is that the advice in this presentation is based on what we know right now from the Information Commissioner's Office, and you have the URL there for you. But please watch this space, because this whole landscape is going to continue to change, as it has done since GDPR came into place in May 2018. And there will be updates, particularly over the next 6 months, about some of the key areas we're going to be covering today. They are the best place to go to. We will be keeping a watching brief, as we have done on the website, picking up on any issues. We'll send it through on Twitter through @NCORD if you want to follow us, but also through our newsletter as well, and through the stream of work that we're doing for Heritage Digital, so that we can keep you pace with the changes. So before we kind of again home in on some of those issues, I want to remind you about what we mean by personal data and the context of how we process personal data across UK heritage organisations. So first of all, definition: personal data is information that relates to a living identifiable individual. That could be someone's name, that could be their address, that could be their date of birth, their postcode. But I would say that actually, in many respects, context is important, because a name on its own, particularly if it's a common name, could be perhaps difficult to identify to one specific individual, but put together with other information could create personal data, the context in which you're using something. Within the context of heritage organisations, the type of information that we're likely to see would include membership lists. So that could be of people that have joined us, that could be people that are engaging with one-off activities or on a long-term basis. Many of us will process personal data that relates to our customers, our clients, our users, our visitors as well. And that could be both digital, but that could also be in the form of something like a visitor's book. Okay, so where someone comes in, remember those dizzy days back a year ago when people actually came into our heritage, were able to come into our heritage organisations and signed our visitors' books? Okay, that's a really good example of personal data that we might capture on paper. And also don't forget that when I'm talking about this too, I want you to bear in mind too that yes, many of us will use Excel spreadsheets and databases, whether they're custom or bespoke, or off the shelf, but also we'll be using filing cabinets and files to store paper records. I want you to remember that it's not just information about our visitors and our clients and our customers, but also personal data will relate to information that we're holding about our staff, our trustees, and our volunteers as well. We should also bear in mind too that personal data will be embedded within many of our collection items. So that could be within our collection records, archival records, names and addresses of people, for example, on letters that we receive or we're holding, or lent to us, or bequeathed to us, or on deposit with us, or part of our collections. That could also include images of people that appear in photographs, and potentially also other types of artwork as well. Now, here I'm going to drop in just a mention, a reference. It will come back through in one of the questions that was asked through Padlet. But within the UK's legislative framework, we do have certain exemptions that enable us to process personal data. And perhaps one of the most interesting and important ones are for archives, and it's the archiving in the public interest exemption. And many of you who are working as archivists, who have archives, perhaps you form part of your heritage organisations, will be aware of this. And I would certainly flag to you to go to the National Archives website to find out more about archiving in the public interest as an exemption that relates to archival records and our obligations in terms of the data protection legislation. Okay, so just a quick aid memoir about what we're talking about, a vast range of personal data. I also want you to be aware as we go through our presentation today that there is something called special category data as well that many of us will be processing. And that relates to perhaps our obligations under other pieces of legislation to capture maybe information about the sexuality or religious orientation or the gender or the sex of our visitors and our staff and our trustees. So that special category information is really information about us that perhaps we all want to be kept private, that is private to us. That would also include trade union membership or membership of a political party. Okay, so that's another example of information that we need to be careful of and be aware of with regards to our obligations as heritage organisations in terms of data protection, but even more so post-Brexit. Okay, now, big question. What has happened since Brexit? Okay, now I've been doing some research. It's been fascinating. I've been looking at the UK's withdrawal agreement. I've been looking at the UK's free trade agreement and trying to kind of unpick a little bit of the history in terms of what's been going on. And actually, interesting enough, a lot was decided before the 1st of January 2021, and even before we signed up finally to the free trade agreement on the 24th of December 2020. But kind of some of the preparation we've actually seen going all the way back to May 2018, and when GDPR came was transposed into UK law, because there were provisos made even then that the GDPR, which was a European originated statutory requirement, from the point that the UK left the EU, would revert into our legislative framework as UK GDPR to sit alongside our Data Protection Act of 2018. Now, long term, this happened, as I said, this piece of change happened rather immediately. Long term, we need to just bear in mind that there are other ramifications in terms of Brexiting, which will have an impact both on data protection, and I will be covering next week the impact of some of these other changes, like European Court of Justice rulings. They will have impacts on other types of issues that we're dealing with. But just as sort of, again, a reference for you to bear in mind that beyond data protection, changes to our status and the way we operate out with of the EU will have an impact in terms of judgments, as I said, through the European Court of Justice. Those rulings will no longer apply. Any old ones will apply, but new ones will no longer apply. And so there may be a tie in here as we go forward with regards to data protection. So the bottom line for you to remember, even though we've left the EU, GDPR still applies. So everything that we signed up to that was in our legislative framework under our data protection legislation, all the bits and pieces that we had implemented in our organisations to get ready for GDPR and then post GDPR, those still stay the same. Okay, so it doesn't mean that we've abandoned GDPR, the opposite. UK GDPR sits at the heart of our legislative framework. So one of the questions that came through from one of you was, should we be still using the term GDPR in our policies now? And if not, should we rewrite our data protection policy to remove this term? So my recommendation and our recommendation for you would be that whilst you don't need to do any significant changes with regards to reference to GDPR, it would be more accurate and preferable if you could change your documentation to refer to UK GDPR. So this means going back over your data protection policy, going back through other policies that relate to data protection, perhaps your records management policies, going through your privacy notices and making sure that the reference is correct and appropriate. So it should be UK GDPR. Now, some of you, and hopefully most of you, would also have amended some of the forms that you're using to collect information about individuals. So this might be consent forms. It might be just your general customer forms that you're using when you're collecting information about potential customers or clients or visitors, etc. Or even documentation that you're using with your trustees, with your staff and with your volunteers. Many of you hopefully would have already got at the bottom of those documents, those forms, a reference to your privacy policy and a reference to the legislation in place. Okay, now there is a really good reference point for you to go back to and to amend to UK GDPR. Okay, another question that we've had through is, does Brexit change interpretation of Article 89, safeguards and derogations, the archiving of personal data being of particular relevance to our digital community archive, which focuses on genealogy? So this refers to the exemptions that I mentioned, archiving in the public interest, and also the ability to access personal data for the purposes of scientific or historic research. And here again, I would like to sort of clear up any myths that yes, these exemptions and the interpretation of Article 89 still do apply. So those of you who have asked the question should hopefully be breathing a sigh of relief that these exemptions will still be relevant because GDPR has been incorporated within UK copyright, the UK legislative framework as UK GDPR. Okay, so another question before we roll on to some of the other topics that I wanted to cover today is, how big are the changes to our data requirements likely to be, and how long will the UK organisations have to implement the changes, in your opinion? Well, although we had a pre-warning since 2016, since the referendum, that we were going to be leaving the EU, and I guess the framework that UK government put in place has remained actually pretty consistent for some time. We've been given a heads up from UK government. I think probably a combination of the year that's been in terms of COVID and our needs to change how we operate and function. And also, I guess maybe just the reality for us of the fact we're no longer part of the EU has possibly delayed maybe some of the areas that we perhaps should have already started thinking about changing. So in my opinion, I would suggest that the areas that I'm outlining for you today should be looked at and reviewed as soon as you are able to do that. I don't think that there is an excuse or any sense of a delay in putting these changes into place. And as we go through the presentation today, particularly when I'm talking about the adequacy arrangements, or waiting for the adequacy arrangements, which I'll explain to you as we go through, and also even the point that I just raised about GDPR now being, and should the need to refer to it as UK GDPR, I think that those are good examples of areas that really need to happen now. So in my opinion, I don't think there is a delay that we can justify, and that we need to really, as a result of this webinar and the guidance that we're going to provide to you following the webinar, we should be moving forward with these changes as soon as we are able to. So what is the role of the Information Commissioner's Office now that we've left the EU? So again, to remind you, the Information Commissioner's Office doesn't just provide a regulatory framework for data protection, but also covers other areas which for some of you will be important, such as the Freedom of Information Act, both England and Wales, but also the Scottish variant, public sector information regulations, or the reuse regulations, and there are also other similar types of information law compliance issues that it is a supervisory body for. So that role hasn't changed. And our strong advice, which I will reiterate at the end of this webinar, is for you to check the guidance and tools, and also particular areas of interest and use should be the data breach reporting issues that are covered, and also advice that the Information Commissioner's Office has provided on data subject access requests. And here I would just give you a little reference with regards not just to Brexit, but particularly to COVID, that in the sense that many organisations are inaccessible due to lockdown and similar restrictions, the Information Commissioner's Office has provided updated advice for everyone about DSARs and the time periods in which you have to respond. And so whilst hopefully many of you will know that if you do receive a data subject access request, you would normally have up to 20 working days in order to respond once you had received the full information that you needed, including verification of the ID of the person requesting. The Information Commissioner's Office has given more advice about the potential to achieve an extension to that period of up to 90 days. So I would recommend for some of you whose organizations are shut, who are receiving a data subject access request, that to look at the advice that the Information Commissioner's Office has provided on that issue. So the long and short of it is that now we've left the EU, the UK government will continue to work with the EU and continue to retain the close relationship that it has with EU supervisory bodies. And certainly if you require further advice about data protection and how it relates to your organisation, and I will again refer to this at the end of the webinar, we would strongly recommend the sectorial support that's offered by the National Archives and also Collections Trust in order to provide information, general information about what data protection compliance means to you or means for you. So let's move on to another issue that's covered by today's webinar that we thought was important for you to understand, and this is the issue of adequacy. Now, because the UK has left the EU, it's now referred to as something called a third country. And these are states that fall outside of the GDPR zone and would also include member states plus so the GDPR zone includes EU member states plus Norway, Liechtenstein and Iceland, but doesn't include the UK. And the GDPR provisions, and as I said, now we can refer to it as UK GDPR as it's implemented in the UK, restricts the transfers of personal data to third countries unless personal data is protected in another way or an exemption applies. Now, some of you may have possibly clients or customers, you may have even staff or volunteers or trustees, people that we work with or partners who are based in the EU. And so the issue of adequacy becomes hugely important for you. Now, prior to our exiting of the EU, there were concerns that it would mean that from the 1st of January 2021, adequacy would no longer apply, and therefore it would disrupt the free flow of personal data from the UK to the EU. This was a big concern to many of us. But the good news is that the EU and the UK have come to a cooperation agreement, which means that certainly for at least 4 months and hopefully for 6 months, personal data that's transferred between UK organisations, including obviously UK heritage organisations, and the EU can continue to flow freely without interruption. And the aim is that following this 6-month period, the UK will achieve the status of adequacy. In other words, if you think about what adequacy means, it means that we've demonstrated that we have a robust enough framework for personal data continue to flow freely. Now, I guess my feeling is, my opinion is that we probably will get adequacy status. However, as in life, I cannot categorically say that this will be the case. Okay, so what does this mean for you? Now, if you have any personal data, as I said, that is being transferred to the EU, okay, so that would be underpinning any kind of sort of relationships that your organisation has, where there is the processing of personal data, whilst this cooperation agreement has given us effectively 6 months good grace in order for this personal data to flow, it's really important that we put in place, all of us take responsibility now, and herein I give you a good example of why we can't wait to put in place some of the measures we're saying in this webinar. We put in place right now provisos just in case we don't get adequacy status or another agreement has come to. Okay, so we do not absolutely know that this will be the case. So what does this mean for you? This means for you that you need to make sure now that you start tracking the data that you collect, that you process about other people, personal data, and that you put in place robust data transfer agreements. Now, if I can come to the first issue, this means that as part of if we go back and look at what GDPR meant for you in May 2018, when it first came into place, it meant that there was a greater obligation as you, heritage organizations, in your role as data controllers, i.e. that you're making decisions about the personal data that you're processing, okay, and that could be through a whole range of different activities that you're involved in. Even back then, there was an obligation on all of us to complete what we call ROPAs, and these are records of processing activities. This is where you clearly document what personal data is being processed, why, where you're holding it, i.e. what systems you're holding it in or filing cabinets, how long you're holding on to it for, and link this very clearly to retention schedules. Now, this was an obligation, and I would say that the lack of a definite adequacy status is another reason why all of you will need to revisit your ROPAs that you have. And I suspect many of you did complete ROPAs prior to GDPR coming into force, or maybe just after. They really should be done on an annual basis, but this is another reason to visit your ROPAs, your record of processing activities, so you know exactly what types of personal data are running through your system. You have a kind of a snapshot. This is going to be important because if there are any kind of obligations on the UK post this 6-month kind of good grace periods, if you've already started tracking what personal data you're processing at this stage, it means you're in the best possible position to be able to comply with any additional responsibilities we may find ourselves in. Okay, so carrying out ROPAs is a good thing anyway, making sure you've got up-to-date ROPAs so you know exactly what personal data you have. Fantastic for being able to deal with data subject access requests, right? Because if you don't know what personal data you've got running through your systems, you can't address a data subject access request. And also really, really important, and this is a key principle in the data protection legislation, if you know what you've got, you can do so much better in terms of keeping it safe and hopefully avoiding wherever possible data breaches. Okay, so lots of reasons why ROPAs are important. Now, the second next step for you following Brexit and the data protection obligations that you have is to make sure you have really good agreements with regards to any data transfer that's going on between your organization and another organization. Now, what I've done for you, and we'll come to this in a little bit, is I've given you some links or a link to some good templates that might help you. Okay, and we will hopefully be doing more work on this area as we go through, but both of these issues are going to be absolutely fundamental. If you've got contracts with a supplier, maybe a software supplier, collections management supplier, and there's a transfer of data, maybe they're holding on to that personal data for you on the collections management system on their server, please review the agreement that you have with them and make sure that it's compliant with your obligations, you know exactly what's happening to it, and other legal obligations that you will have as data controllers. Now, another question that's asked, and I want to come to, is the importance of a European representative during the transition period, okay? And this is post-transition period as well. So now that we've left the EU, some of you, particularly the larger charities that are represented today, maybe some of the national museums or larger local authority funded heritage organizations who are on a regular basis trading between the UK and the EU, or you have a large body of customers or clients, will need to consider whether to appoint a representative in the EU. Now, this is actually really interesting because some of you, like me, may have captured or read the news item on the BBC News channel this weekend about the recommendation. It wasn't government, but is a recommendation that if you are a UK business and you're operating in the EU, that you actually effectively set up an EU equivalent so that you can trade more easily and also provide you, I think, with an opportunity to put in place measures that reduce the likelihood of additional charges and administration. So this kind of is actually a really nice tie-in here. So do have a look at that news item as well. But I do think, again, that some of you perhaps who don't have an EU representative already, and as I said, this is for large scale transfers of personal data between the UK and the EEA, will need to consider the appointment of such a representative. In this case, I would strongly recommend that if you haven't done so already, that you check on the Information Commissioner's Office website for further information and also for further guidance about what you will need to do and what you need to be considering. And so this is a question that we've had through on Padlet, so thank you very much indeed for sending this through. If a charity has a charity shop that sells goods to residents of the EEA but doesn't target EEA residents through catering to their language, is it as an EU representative necessary? And the answer I can therefore give you is a strong possibility that yes, it will be necessary. Okay, I would again in this instance suggest that you jump on the Information Commissioner's Office website and have a look at their guidance and answer some of the questions that they've asked you in order to establish that particular issue. But again, this links back to the point I made just now about, as a business generally, thinking about the benefits of potentially setting up a sort of a trading arm, perhaps in the EEA as well. Okay, so I'm not sure how many of you this will affect, but it's an important point that we cover today, which is about EU domains. So any heritage organisations on board today or charities that have a .eu domain name will now have been cancelled. They have been listed as suspended until the 31st of March 2021, but after this point, they will no longer function. So just as an aide-memoire, we want you to be aware that this is the status. If you're thinking about buying a .eu domain, but you're based in the UK, I'm not sure that you're going to be able to do that as well. You will still be able to reinstate them if you meet the eligibility criteria. But as I said, from the 1st of April 2021, your domain name that's not in compliance with the regulatory framework will be withdrawn. And you'll need to think about whether sort of, I guess, the cost benefits analysis and also sort of general eligibility criteria, whether those mean that you would want to reinstate the .eu domain or whether you'd need to think about an alternative. But this is really, again, an important point that's happened already, and you will need to make sure that really from now on that you review the status of your domain names, the .eu domain names. Right, so you'll be pleased to know that actually we've covered what we believe to be some of the substantive issues relating to Brexit, data protection and heritage organisations. Bear with me though, because after Streams 2, I am going to be looking in a little bit more detail about what you need to do next, what our recommendations are for you following this webinar. So, Streams 2, nothing to do with Brexit. It was a case that went to the Court of Justice of the European Union, the CJEU, and it was a case that actually really came up with two important points for us to bear in mind. One is the validity of the EU-US Privacy Shield. So for some time, the US has relied on the Privacy Shield in order particularly to give its EU customer base reassurances that it was a secure and data protection compliant way or data privacy compliant way of enabling the transfer of data. And also prevented US surveillance programs from accessing EU citizens' data beyond what was regarded as strictly necessary. So this particular case that went to the CJEU invalidated the EU-US Privacy Shield, meaning it was no longer a GDPR-compliant mechanism for sending data belonging to EU citizens. So actually a pretty significant case. Now, don't forget that I said earlier the cases that relate to court judgments made in the EU, the Court of Justice of the European Union, for example, those still apply. It's cases from now on that will no longer apply to the UK, although please bear in mind too that whilst they won't apply per se, cases that do go to any kind of courts in the EU, there may be referenced or may inform decisions that the UK may make. Okay, so just to kind of caveat that very slightly, and I will be picking up on that through the lens of IP law and copyright law next week, if you want to jump on our webinar then. Now, another part of the Shreems case also questions the efficiency of standard contractual clauses. So these are referred to as SCCSs, and these, just so you know, are normally made between companies who receive data and companies who send the data. And what they seek to do is to ensure that the data in question is protected to the standards required by the EU. And this particular case highlighted that not all standard contractual clauses are adequate and sometimes need additional measures. And this actually ties in quite nicely to what I was saying earlier about needing robust data transfer agreements. So what does our Information Commissioner's Office say about that? So in response to the Shreems 2 case, and actually, if I can just say as an aside, not all contractual clauses anyway are necessarily fit for purpose. So the ICO has confirmed that they are actually in the process of reviewing these recommendations and also reviewing the European Commission's new GDPR SCCs that are currently under consultation. But what they recommend and what we also want to forcefully impart on you is to please review any international transfer agreements that you have in place and update these as necessary, and also keep an eye on what's developing. Now, I did reference that we have some templates. Now, I did jump on the European Commission's website this morning, and what they have so far are 2 sets of standard contractual clauses which relate to data transfers from data controllers in the EU to data controllers established outside the EU or European Economic Area. And there is also 1 set of contractual clauses for data transfers from controllers in the EU to processes established outside the EU or EEA. And I've given you the link here. Now, I do think that these have huge value, and I would recommend that those of you who are worried about your standard contractual clauses jump on to the link I've given you, have a look at these as a really good starting point, perhaps for refreshing your own, but also, as I mentioned, please watch this space and we will let you know what the ICO says in due course about standard contractual clauses, but hopefully this will give you a good kickstart in terms of revising your own. So the question that we received from you is, does the Privacy Shield still apply for UK-US data transfers after being validated by the EU? And I think the answer is a categorical no. And if not, do standard contractual clauses set out by, say, MailChimp, SurveyMonkey and Eventbrite offer enough security? So the answer is, I think, as we would always say, please do review every website, platform, third party that you're using to process your data, i.e. a data processor, to make sure that your organization understands what they can promise and what they don't promise, and to make a judgment call yourselves about whether you think it's fit for purpose. Now, my strong belief is that if they haven't done so already, many of these platforms will be revising their standard contractual clauses to make sure they are more robust because of their inability to rely on the Privacy Shield. But ultimately, it's down to your organization making sure that you understand and whether you believe that the platforms that you're using, including those that we've listed and others, are fit for purpose. Ultimately, it's your responsibility. It's your organization's responsibility. And this is clearly outlined within your data protection compliance obligations as a data controller. So what's next for you? Now, as we said always, ensuring a rights and privacy culture, or rights and privacy by design culture, is absolutely essential to make sure that your organization is compliant with its legal responsibilities, not just data protection, but also one of the other areas that we work in is copyright. So what we would recommend is implementing within your own organizational culture our compliance methodology, and this means that you have in place robust governance structures to ensure that there is a clear line of reporting and I guess buy-in from senior management team, and a clear framework in order to support your compliance culture, that you have ensured that your forward plans and your planning ahead takes into account all your information law compliance obligations, that you reevaluate your policies. That would of course be your data protection policy, but that might also be your volunteers policy, your HR policy, your collections management policies, your copyright policy, to enable them to be as updated as possible regarding your legal compliance obligations, that your procedures are fit for purpose, and those would be including your procedures to deal with a data subject access request, ensuring that data privacy impact assessments are carried out if there is any change to what you're doing or something, a new activity, for example, using a piece of software that perhaps is hosted locally to then enabling you to move perhaps to a cloud-based alternative. A DPIA would need to be carried out for that purpose, ensuring that your systems and tools are fit for purpose, and also fundamentally making sure that everyone knows what they're doing. They know their data protection obligations, they know how to identify a data subject access request, and perhaps those of you that are both needing to carry out data subject access requests, but also are subject to FOI, knowing the difference between the two, knowing how to deal with a data breach if one happens, so keeping awareness high. So that is our recommendation, but I'll be picking up in a moment on more detail about what we recommend generally, but also post-Brexit for you as heritage organisations to make sure that you are doing what you need to do next. So a question that's come through to us as well through Padlet is there the slightest chance that we might be able to carry on with the existing policies? And I think that the answer is, generally speaking, your policies at the very least should be reviewed every 2 years, but we would strongly recommend an annual review of policies anyway. Number two, I think that from the presentation that I've given today, that there will be changes and nuances that you will need to be making to your policy framework to take into account both the changes that are happening now, but also that might be around the corner with regards to some of the decisions that the ICO and the European Commission will be making. So I would say, and this is, I mean, you can ask me this question anyway, that I'd probably say that having old policies is as good as having no policies at all, that really your policy should always be up for review, and this is a very good opportunity to make sure that you review them and you amend them accordingly. A summary of my recommendations. Okay, so we filtered out the noise of Brexit through this webinar for you, and we focused in on what we believe you need to know about as heritage organisations of various sizes and shapes, of various different types of collection types and governance. But we would say that for all of you, the key areas, our key recommendations for things that you need to do next are, number one, check your EU, if you've got any .eu domain names, they will be suspended from now on. You'll need to make sure that you satisfy the eligibility criteria in order to retain them. Think about alternatives if you do no longer qualify for them. Number two, if you don't have an EU representative already and you think that you might need one, either or because of your data protection obligations and your client base and your processing of personal data, or just from a business perspective, this is a time to put one in place or to think about how you're going to achieve that. Number three, all of this needs to be outlined in risk registers to outline what you're doing and why and what you need to do next, and obviously clearly mitigating activities that your organisation puts in place is absolutely fundamental. Number four, make sure you revisit your standard contractual clauses, your SCCs, or your custom contractual clauses as well. Okay, if you've got contracts that are coming up for renewal, or you've got high value or high risk contracts, if you want a place to start, that would be where we would recommend that you start, and then gradually work through the rest of them and make sure that they are fit for purpose. Please jump on to the link that we've given you. There hopefully will be more guidance about standard contractual clauses coming through shortly, but we think that that's a very good start. Check your data transfer agreements. Okay, any transfer of data and your obligations are going to need to be even more, I guess, in terms of keeping that personal data safe, you have to be even more rigorous. Your accountability to making sure that any personal data that's transferred legally to other parties, that needs to be encrypted, or you need to find other technological ways to keep it safe. Please update your privacy notices accordingly, even if it's at the very least just changing GDPR to UK GDPR. Make sure that it lists very clearly the types of ways in which you're processing personal data. By the way, don't forget to change the date at the bottom from 2020 to 2021. Always a good tip. I've talked about ROPAs. Okay, make sure that you understand what data is being processed in every department. Okay, those need to be happening anyway. Please use these as an opportunity. And finally, what you can also do to help yourselves, and again, this ties in very well with your cybersecurity obligations, which is the safeguarding of personal data, whether it's anonymization or encryption. Okay, and just some general recommendations as well that have come through from the ICO recently, and just kind of giving you a big picture reason, again, why this is also important. The European Commission's adequacy decision, which is pending, is a reason why we need, if nothing else, to reassure those in across the EEA that we are keeping their personal data safe. And I guess pre-warned and as being forearmed and all that, but if you can make sure that already you think about the sorts of responsibilities you have regarding personal data, maybe this is an opportunity for a discussion in your organization, and having a document perhaps that you can even provide to those that might be asking for it in due course. Your organization may be asked in due course to clarify how it keeps data safe and its responsibilities with regards to personal data. So we're really at the end of this presentation for you. I'm going to give you a sort of a few more tips about where you can go for help, but I thought this was a good opportunity to just find out how meaningful this webinar has been for you today and how much difference it's made. So I'd like to open the poll up again. This is poll number 2, similar question, but we would just like to know if you'll be doing anything different regarding privacy issues following this webinar. So if you could vote now, yes, no, maybe, or don't know. I'll give you a few seconds to add your answers in. Okay, so it's gratifying to see the results that have come through. We've got 81% of you, so that's 187 of you today believe that you will be doing things differently. So that's great, because it feels that the information I've given you is useful and that there are some practical steps for you to follow up on. And we've got 4% of you, so that's 9 of you have said no. We've got 13%, 31 of you say maybe, and we've got 1%, so that's 3 of you who don't know. So thank you very much indeed for taking part in the poll. I'm going to now just give you a little bit more information. Where should our new go-to source of data protection guidance be? And I'll come to that in a moment. And another question are templates to organise and agree sharing of data between collaborating organisations, and when should we be using these? So the second question first, I've given you some links to templates, and you really should be using these from now on, please. But you know, by all means, jump on our website. We'll be putting out more information, and also really crucially, where to find out more. The Information Commissioner's Office website is a fantastic source of guidance and advice. So do have a look there, see what they're saying. They will be, as I said, making SCCs more widely available as they kind of proceed with how they're moving forward. Our website contains lots of stuff for you. There's also information on the charity digital website, and we'll be producing guidance following today's webinar. And finally, we would like to suggest the National Archives, as well as providing some fabulous information about data protection, particularly for archival organisations. We've got a book out for you, which should also give you some useful guidance. There is currently an offer of 30% discount of it, so the Info Law 30 will reduce the price significantly, and you can get more information from Facet Publishing, our publishers. So I want to thank you all very much indeed for bearing with me, for listening. I hope that you have found the webinar useful, and I would like to invite Carmen to join me now for questions that hopefully you've been posting during the course of the webinar. So thank you all very much indeed.
Hello again, and just thank you, Naomi, for all of that information. And I think I speak for everybody in our virtual room when I say the slides and the guide for this are going to be invaluable to actually implementing it and sort of sitting down and working through. And it's a lot of information, but you put it so succinctly and helpfully. So thank you.
Thank you, my pleasure.
Right, we have had some questions coming in on the Q&A. I am going to start with possibly the easiest one, I hope, and it's from Gordon McKenna, and is it UK GDPR one acronym, or is it UK space GDPR?
Okay, thank you very much indeed. And Gordon, lovely that you could join us. Gordon and I go back about 20 years, so thank you very much indeed. The answer is, I'm going to check that for you. I would, I'm going to check that, and I know that you would want the precision of the answer. So if you could bear with me, I'm actually going to put out the answer on Twitter. Okay, so please, everyone who wants to know whether it's specifically UK space GDPR or if it's one word, I will put that out on Twitter for you just to be 100% certain about my answer. I think from a sort of, I guess, a practical perspective, I don't think it's going to change the world either way, okay, to reassure you, but I think precision is important. And I want to make sure that I give you the correct answer. So please bear with me on that one. But thank you, Gordon, for that. It's a great question to start with.
And the next question comes from Lisa Gaunt. And I know you touched on servers earlier, but Lisa's question is, what are the implications for cloud storage, i.e. location of servers?
Okay, so I think that the benefits of the data protection legislation in which we operate is that we have UK GDPR, space or no space to be finalised, and so does Europe. And it means that we all know that we've signed up to and we comply with these sort of very high kind of level requirements in terms of how we process personal data and how we store things. So I think your question is very, very good. I would say that servers that are located in somewhere in Europe are actually those whereby we can take much more reassurances that they will be holding data or our data in ways that are compliant with the legislative frameworks in which operate in their countries, i.e. GDPR. So that's actually that's kind of reassuring for us if it is in the EU. That's number one. Number two, if servers are held or servers are located outwith of the EU, and also based on the Schrems case and the fact we can't rely on the privacy shield, I would say there that we should be a lot more cautious with regards to storing our, or I mean, when I talk about our personal data, I mean personal data that we're processing. When we're storing data on those servers, and we would want reassurances contractually to make sure that they are compliant with the high standards of data protection compliance that we have in the UK. Okay, and that's where your contractual agreements are absolutely fundamental. And I would say that in my experience, one of the most important areas beyond what you would normally see in data protection clauses is that if your data is stored on any kind of software or system or with a third party, that there is an immediate notification to you if there is a data breach. So that, I think that hopefully sets the scene for you. Great question. But what I would also say to the reverse of this is that now that the UK is out with of the European Union, I would actually expect that if people are using our servers, although right now our GDPR framework is, UK GDPR is equivalent to, I guess, EU GDPR, over the fullness of time, there is a possibility that our compliance obligations will move further away, and therefore there may be obligations on us to actually demonstrate more to others, particularly in the EU, that we are looking after personal data to the high standards that they would expect. So I hope that helps with your answer. Hope that helps with answering your question.
A couple of people saying, just thanking you for the presentation, Naomi, and saying they have to leave. We'll try and answer the remaining questions in here. So if you have to leave, please leave. Know that it will be recorded. But if you don't have to leave, then listen on. There are two questions that relate to that previous question. So the first is anonymously sent in, and I think you've answered this in various ways, but in case there's anything on top to add, can SCC, standard contractual clauses, apply if the processor is based in Europe and is transferring personal data from Europe to the UK, i.e. personal data is stored in a cloud based in Europe, but the data controller is in the UK?
I would say yes. And in that respect, if I've understood the question correctly, the UK would take the role as the data controller, and then the storage facility would be the UK, would be the data processor. So I guess in that respect, if it's, again, data that's being processed elsewhere, we need confirmation as data controllers that that data is being held securely and in compliance with data protection obligations. So I don't think that there's any difference, and I do believe that we would still need sort of contractual reassurances that that content is being held in a way that we would expect and that's compliant with our obligations.
So similarly, and I suspect the answer will be similar, it's from Laura Dixon, and it's, hi Naomi, we have 3 registered domain names, including a .eu one, as we are a cross-channel collaborative project. However, our website is created and maintained in France, and in the UK, publicity, we are only using the .com name. As a lead partner though, do we need to worry?
I think it depends on who registered it, to be honest. So thank you very much indeed for that question. And I think that what I would suggest is that whoever registered that .eu domain name checks their eligibility criteria, and to ascertain whether they are still eligible to have it. I suspect also that you probably would have received some kind of notification that your .eu had been suspended if the eligibility criteria were no longer satisfied. But if it's one of your partners based in the EU who's registered it, then I don't see any reason why that would be a problem. But again, if you have any doubt or you want clarification, please do check the eligibility criteria. But thank you for the question as well.
Now, we will go to, let's have a look, one from Rob Thompson. If your organisation uses Eventbrite or even WordPress or GoDaddy, are their user agreements reliable? Not clear from previous if that's been covered. I suppose you can't necessarily comment on the individual sites.
Right. And I think that this is really why, I have to sort of firmly put this back at heritage organisations, with sort of your own kind of your requirements, how you operate and how you function generally, who has access to that content, what type of content you're storing on them, how often do you review them, the context of the activities you're involved in. And then for you then individually as heritage organisations to take a risk assessment about what you're doing within the round. So whereas Naomi Associates uses some of those platforms, I've taken a risk assessment and I've taken a big view as to what data is being stored and why and for how long, and all the other measures that we have in place as a company that comply with our data protection obligations, and made decisions for the company accordingly. And that's what a privacy by design culture is asking you to do. This is why the ICO and the requirements in GDPR are all about carrying out data protection impact assessments, so you as an organization can make that decision within the round of everything else that you're doing. So I'm not really giving you an answer yes or no, am I? But I'm just saying that you will need to evaluate it according to your specific circumstance and those activities. So I hope that does help, or at least gives you a pathway to make the decision.
Right, now a question from Sarah Kuklovic, and I hope I pronounced that correctly. If we need to share data between members of staff, and I presume this is kind of cross UK and EU working, can we email it? So sharing data between members of staff, can it be emailed? The presumption is between the UK and the EU.
The answer is, I guess, I don't really know, because I don't know the circumstances in which, why you've collected the personal data in the first place, what it's being used for, where your staff are located, why you would want to do that, and whether they're staff from the same organization or from different organizations. So the answer is it depends on what you're doing. So if you just kind of go back to basics with regards to data protection law, you really should only be processing personal data if there's a lawful basis for doing so. And if that means then you've collected it for one reason and then you're giving it to someone else to use for another purpose, then that's actually out with of what you're supposed to be doing, what you're allowed to be doing with personal data. So
Sarah has added in,
yeah,
e.g. for shop sales, if someone is working from abroad.
right. Okay. So they're working abroad on that particular activity. Then what you need to be doing is making sure that if that does happen, your organization documents very clearly the activities that are taking place, that you think very carefully about your cyber security provisions, and to make sure that your online security particularly is as robust as it can be. And there's a whole stream of work that we've done already for the Heritage Lottery Fund, and that's available through our guide to online security and privacy, where we outline some of those issues for you. So this is really the sweet spot between data protection, compliance, and cyber security. So the answer is, again, it depends, but you as an organization need to reassure yourselves that you have in place all the necessary frameworks so that any even lawful transfers of data in that type of situation are perhaps, you look at how you encrypt data, you look at how you keep it safe, you look at potentially encrypting documentation that's passed between different people, that your emails are secure, that you're using the same systems, that your software is up to date. Okay, all those sorts of issues come into play. And if I again could reference you to some current news that was on, it's on the BBC's website, I think today, or if I've lost sense of time, possibly yesterday. Actually, that cybercrime now is one of the biggest threats to UK businesses and to individuals. So another reason when you're looking at data protection compliance, it must be done hand in hand with your cyber security obligations as well, and is also a legal obligation under the data protection compliance legislation that we have, which is to keep personal data safe. Okay, so I hope that answers the question.
Right, I was about to say final question, and then two more questions popped in. So the not even penultimate now question is using the umbrella term data protection legislation acceptable in amending policies and privacy notices rather than UK GDPR in whichever form?
Okay, so that's a very interesting question. So that's what we've done. We've taken a view that UK data protection legislation, or the data protection legislation, is a great kind of catch-all term to use. But any time that we've used that, we've defined it first as the Data Protection Act of 2018 and UK General Data Protection Regulation (brackets GDPR). And then after defining it, we've then used the term the data protection legislation. So in my opinion, as long as you've defined it, I think that is a good way forward.
Okay, and another from Rob Thompson, he says, me again, if your charitable heritage organisation uses its local authority IT, email systems and servers, perhaps through a service level agreement, does it have to do its own GDPR checks and updates? I'm thinking of visitor customer databases.
Yeah, definitely. Yes. So absolutely. So I'm having worked with some of you that are local authority funded. Yes, you will have your kind of umbrella policies and procedures that your local authority will make available to you. Your local authority will almost certainly have its own data protection officer. But across heritage organisations, there are always going to be lots of different types of activities that are kind of slightly nuanced. And so I would suggest that it's strongly recommendable that you have your own sort of sub policies, perhaps your own privacy notice that outline very clearly the activities that you are doing that are unique to the heritage organisations funded by the local authority. And by all means, share them with your local authority DPO and get your DPO, the local authority DPO, to sign them off. But I don't think that the local authority policies will be adequate to cover all the activities that take place across heritage organisations that it funds. Can I say, Carmen, to all of you, these are great questions, and thank you so much for kind of putting them in and adding in extra bits and pieces. This sort of enriches the webinar that we're running today. It contextualizes it. It gives other organizations a real sense that they're not alone. And I think this is really kind of, if you like, one of the last things I wanted to say, which is that all of us are in this together. You know, all of us are having to grapple with sort of a changing landscape, lockdown, and all the kind of questions and involvements that you have brought to this webinar will hopefully give you all a sense that there are certainly things that we need to do next, but the networks that you can tap into, whether that's through your museum development officers, through the Heritage Alliance, through us at Heritage Digital, will hopefully mean that you can also work collaboratively with other organisations, or at least share what you're going through, and you know that we can all help each other through this and through particularly what we have to do regarding data protection post Brexit.
Completely agree, and I really enjoy this program because I manage it, but I really miss the ability to sort of speak to people face to face, network in the little events. I've attended a couple of your events over the last sort of 6 years, and find them really useful for that kind of that Q&A bit, or saying like, well, this is my example, I'm a collection adjunct to a local authority, like, what do I do? And you don't have that now. We're all just sort of siloed, so it's a really lovely experience. And I think the benefit of this being heritage wide as a project means that we can see questions about shops, we can see questions about people working with people in the EU on projects, we can see collections management questions, and it kind of triggers different thoughts in your mind. So with that in mind, the final question we'll take today is from Patricia Peterson. We use a digital asset management system for storing and managing all of our images, videos and audio clips. What is the most crucial thing we should think about with ensuring we're compliant?
Okay, so do you know, I could talk to you all day about this particular issue, but let's just try and keep it succinct. Thank you very much for the question. Off the top of my head, right, I think that if you number one is making sure that you know what data you're holding on your system. Okay, so this is your record of processing activities. Know what you've got, how long you're holding on to it for. Bear in mind that it's as long as you need it, which in the case of collections information is probably as long as you've got that item in your collection at the very least, okay, i.e. in perpetuity, one would hope. Second of all, I would make sure that you have a robust agreement with your provider. So with the collections management system, with the digital asset management system provider, and make sure you know where they're located. As I said earlier, if they're based in the EU, greater reassurances that they're holding on to data that's compliant with sort of EU GDPR and therefore at the moment UK GDPR. Revisit that agreement, make sure that it does everything you need it to do. If there's a data breach, for them to tell you immediately, no more than 24 hours if there's a data breach. Okay, there have been some horror stories about collections management systems and also other providers of software that haven't been telling their clients when things have gone wrong. We need to make sure that we've got contractually robust agreements in place in order to do so. Number three would be think about encrypting, okay, and password protecting that information. Not all collections information should be shared with everyone, even in your organization. Okay, so this is about filtering access and authenticated access to certain users only. And I could probably go on, but if we just stop there, all right, as in my opinion, the things that you need to be thinking about. Oh, and just make sure your privacy notice as well is updated to ensure that is something that's stated that you do, data that you are processing. I hope that helps.
Brilliant. Well, thank you very, very much, Naomi. I will do our closing out sort of not robotic ending now. Just to reiterate, the recording and the slides from this session will be made available on the Heritage Digital website in the coming weeks. As ever, and as repeated throughout this, sign up to Naomi Corn Associates, an enormously useful website and the mailing list to get updates. If you want to take the discussion further in the meantime, the Heritage Digital programme has a closed Facebook group if you use the platform, where you can chat with others from the sector, share links, share ideas. If you search for Heritage Digital, you should find it. Now, we hope that you found today's session useful. Look out for the feedback form that will pop up at the end. All of your feedback is enormously helpful. It helps us to plan future events, helps us to know which topics are pertinent, and plan the rest of our programme to July of this year now. So we will see you at another Heritage Digital event soon. Don't forget there is the Brexit and intellectual property event this time next week. Have a good day, everybody.
Take care, everyone. Thank you. Bye, everyone. Take care of yourself.
Bye-bye.
Bye.